and welcome back to another episode of House to Home, a podcast brought to you by Family Policy Alliance Foundation. I'm so excited to be back. My name is Grace Youngson, and I'm here, as always, with my colleague Joseph Kohm. Today, we're going to be talking about a recent court case called Mahmoud v. Taylor, in which parents disputed their kids being exposed to LGBTQ ideology in books in school, and this was disputed against them by the school and made its way all the way to the Supreme Court somehow. So anyway, Joseph, can you tell us a bit more about this?
I would love to, Grace. This is a really interesting and revealing case, and I appreciate you. It's always good to be back on the show with you here this week. So, as you said, this case is called Mahmoud v. Taylor, which are just the party names for this case. For people who are not crazy court watchers, we don't expect you to be as our audience, but that's what we're here for, is to watch the court for you and give you some reports on some important cases. So, Mahmoud is the name assigned to the petitioner side of the case, which is the side representing the parents, because this was a coalition group of Muslim, Catholic, Christian parents who sued Montgomery County school boards in Maryland for exposing their children to books promoting LGBT ideology in elementary school. And Taylor is the last name of I believe, the Maryland Attorney General. So that's where the name of the case comes from. I'm going to summarize the facts of the case from a combination of sources. For the court watchers out there, they'll appreciate that I am referring to the always brilliant Ed Whalen at National Review and his great summaries of the Supreme Court. But I'm also referring to Beckett Law's official summary of the case, because they were lead counselors for the parents. So this is going to be a combination of both of those two. So basically, in the fall of 2022, the Montgomery County Board of Education, that's the county school board in Maryland, announced that over 20 new, quote, inclusivity, quote, end quote, books for its K through 8th grade classrooms. But rather than focusing on basic civility and kindness, these books champion pride parades, gender transitioning, and pronoun preferences for children. For example, one of the books tasks 3 and 4-year-olds to search for images from a word list that includes, quote, intersex flag, drag queen, underwear, leather, and the name of a celebrated LGBTQ activist and sex worker who we won't mention. Another one encourages 5th graders to discuss what it means to be non-binary, quote unquote. And the other books advocate what's called a child knows best approach. And I say that what's called that because it's, we think, a bad idea of the notion that children know who they are from the earliest age, and therefore they should be supported in some sort of gender transition. They're also taught, even more concerningly, that a decision to transition doesn't have to, quote, make sense, and that doctors only guess when identifying a newborn's sex anyway. So then when the parents responded with questions to this, the curriculum they were shown also suppresses free speech and other independent thinking by having teachers tell students that they are hurtful if they question these controversial ideologies. So fast forward to the controversy here in question. A bunch of parents, understandably, were concerned about these books in question, and so they asked for what's called an opt-out, which is where parents can affirmatively tell the school, I don't want my child present for these lessons or exposed to these materials, so you have to allow them to do other activities during that time. Well, a lot of parents asked for this, and initially the board was compliant, but then suddenly they reversed themselves and said that complying with the opt-outs was become too burdensome, so they were no longer going to allow children to opt out, and they were not going to inform parents for when these books might come up in their lessons. So naturally, parents sued, and somehow, Grace, as we could tell from your confusion in your introduction, somehow this made it all the way to the Supreme Court, and here we are. So what do you think of that summary, Grace? What's your reaction to hearing all of that?
Yeah, I think that every single parent hearing this should be as horrified as I am. I mean, I'm not even a parent yet, but as horrified as I am that we're discussing whether or not kids should be sexualized. Like, I thought that we were kind of hopefully past that in our, being civilized and understanding of what is and is not appropriate. And so I think that's my first reaction. The fact that this is like actually an issue, we're actually talking about whether we should be sexualizing kids or not, is really concerning.
Yeah, I agree. And to do it on the public dime, on taxpayer money, that's what funds these public schools. So I agree. Equally shocking, Grace. As a lawyer on our team at FPAF, I'll just take a bit of a legal piece for my first reaction, which is simply that, and we'll get into some of the quotes from the oral arguments that happened at the time of recording. We're recording about 2 weeks after oral arguments, and we're still waiting for a decision. But I listened to the oral arguments, and I have to confess, I feel a lot like Justice Kavanaugh. He said at one point when he was questioning some of the lawyers representing the two sides, I agree with him that I am likewise, quote, mystified, end quote, that this case ever made it this far. I mean, why would this school board fight this case all the way to the Supreme Court? Because opt-outs happen all the time around this country. Grace, parents are constantly opting kids out of things, and not even things this controversial, just any kind of lesson that they're uncomfortable with. So I think the answer, though, as a good lawyer, I try not to ask a question I don't know the answer to. The answer to why Montgomery County School Boards has fought this is very revealing and I think shocking, but I think good for our parents and our audience to be aware of. So that's what we're going to discuss today.
Yeah, and that's why I think this is such an important case to discuss, because if you're a parent listening to this, especially because it went all the way to the Supreme Court, potentially has hugely far-reaching effects for how your children are educated and what they're exposed to in the classroom. And so I think there's so much that goes along with this, Joseph, as you said, on a wider scale. But, here at FPA, we believe that you as the parent should have the right to facilitate the upbringing, the education of your children. That also is supposed to be how the US does it too. The United States, the idea of government here is not something that controls the people. It's something that empowers you to have those basic rights of life, freedom or liberty, and pursuit of happiness. It's not about controlling what you're fed information wise. That would be a far more communistic type of government style. And sometimes I think about this from the perspective of the founding fathers, and I think like if they could see this today, they would be like, oh my goodness, this is not the United States that we created, and I think that's something really important to recognize, is that the government is not your provider. And a lot of people want to make this argument that like the government has to give them everything. Well, when you start making that argument, also that means the government has greater control because they're controlling what they're giving you. Whereas when we're under more of a godly style of government, it's more that the government is our protector and our empowerment to live our lives. And so this really goes against those ideals. And when we're thinking about the future of America, the future that we want our kids to grow up in, I don't want my future kids and grandchildren to be forced to learn ideology that is so anti God's word, it's anti what I believe, and it's also anti their future happiness ultimately.
Yeah, that's well said, Grace. I have to concur that I don't think the founders had a conflict like this in mind when they were drafting the Constitution and the Bill of Rights. I don't think. I'm pretty confident they didn't foresee children being taught ideologies like this in elementary schools on the taxpayer dime. So I think that's what some of the controversy in this case is about, is the government forcing one particular ideology and way to think on the population at the expense of others and at the expense of protected rights. Because you're right, we at FPA believe, as the Constitution says and the court has affirmed, that parents have the right to direct the upbringing of their children. So that was one of the controversies in this case, was whether these materials that the kids were being exposed to actually endorsed these alternative sexual lifestyles, or whether it was neutral. And it became pretty clear, even in the oral arguments themselves, because I think it was Justice Gorsuch who said he actually read through some of the materials. So this is not neutral. This is not one-sided. In fact, one example we have in our notes is that one book described the story of a girl attending her uncle's same-sex wedding, for example. While another of these books, a book called Pride Puppy, told the story of a puppy that gets lost during a pride parade. And that's not us. That's straight out of the record in this case, as reported by SCOTUS blog, which is just a great, helpful website for court watchers like me. So the parents here, it's important to note, they're not even challenging the inclusion of these books in the curriculum, which I do think is concerning. But what they're standing on is that they have the right to direct the upbringing of their children, and that includes kids and how they learn about sex. And so they're within their rights to object to them having to be exposed to this, even if it's part of the curriculum. And like I said earlier, opt-outs happen all the time. So throughout the country, parents opt their kids out of everything. It's a common way to respect the religious liberty of parents to have issues like this. So, Grace, I know you're very schooled in these methods of government, different types of government. You mentioned a difference between our American liberty, as we inherited from your country, the English, and versus a more Marxist style. So, in your opinion, why do you think the board fought this so far, all the way up our court system to the highest court in the United States?
Yeah, I think that's a great question. I mean, I was thinking the other day actually about this. I think that it's very interesting how people who are on kind of the other side to us are very bold in what they will try to bring forward legally. And I was reading something the other day, and what was interesting was someone on the more biblical side was making the argument of like, oh my goodness, if we as Christians try to bring forward, like, we need to have a Bible time in schools, like they would pull their hair out over it, and yet they're bringing forward like we need to have a coming out session or something. What I find so interesting from that is the Christian perspective is almost a little bit like they assume that we're going to lose if we bring something forward, which very well may happen. And I think this is just a greater lesson for us as a whole and for parents. We should have more of a winning mentality in this. And I kind of think that part of the reason they brought this forward is they're testing the waters. And that is what has happened continuously with cases like these. I feel like it's just always, well, let's just see if we can do this. Because, like, what's to lose? And then some crazy things get put through that most Americans would not agree with, but they just went for it. And I
Yeah.
think on our side, we need to have a little bit more of that boldness about us to just go for things. If we lose, we lose. Who cares? At least we tried.
Yeah.
And so I think that is part of this. I think the other side of it is, we definitely have elites with much bigger plans. If this gets passed, this is something, going back to the different concepts of government, that would really paint a bigger picture that when you think about a Marxist system of government, the government basically owns you, and you are valuable to the government and to society based on what you produce. And so the government also wants to control you, to make sure that you're producing for them what they want, which is such an anti-Christian way to think of human life. This goes right back to abortion too. When we think of why abortion, we try to justify it. We often justify it, or some people try to justify it on the basis of like, well, the mother's life is worth more because she is more productive in a sense, or she has more human capacity, or whatever way they try to go about that. It's ultimately more of a Marxist ideology. And honestly, I feel like Marxism is like the most anti-God thing. It's anti-family, it's anti-everything that God and godly values are all about. And that is what is so great about the US Constitution, is that it recognizes our natural God-given rights of life, liberty, and pursuit of happiness. And so I think this case has that broader scope to it as well, of recognizing, if they could achieve something like this has broader cultural ramifications for how we view government and us.
We'll give you two or a couple of pieces of data points from the record in this case, Grace, which I'll give them. Maybe you can respond to them, and then we'll go to our first break in the show today. So I think it's very clear, like you said, they're trying to push a particular agenda. That's what drove this case. That seems clear cut to us, even if we know those constitutional standards of parental rights. It seems clear cut to us, and yet, like Justice Kavanaugh, we're mystified that we're talking about this at the highest court in the land. I think that's pretty clear from the record. Here are a couple of examples. The school board here actually argued, as part of their case, that the state of Maryland has an interest in promoting gender inclusivity instruction, and that interest could be compelling enough to outweigh a parent's First Amendment rights, the right to raise their kids, the right to practice their religion. So that's telling. Also, in the record of this case, you have one of the members of the board claimed that a parent opting their child out of this content because, quote, because it, quote, offends your religious rights or your family values or your core beliefs is just telling your kid, here's another reason to hate another person, end quote. So this board member, and I'm sure this person's not the only one, clearly believes that traditional notions of sexuality and gender and intimacy, whether you're Christian or not, are actually hateful, and it's a way in which you could hate the other person. That obviously that fails to understand our beliefs, Grace, because if you're a Christian, you can't hate anyone. You can hate ideas, you can hate things, you can hate the devil, but you can't hate people because they're made in God's image. And then just as a follow-up point to this, I love the way Ed Whelan responded to this by saying, he wrote, "This case is another example of left-wing culture warriors who aggressively go after religious families with the power of government and then act shocked and disappointed when there is a legal and popular pushback."
Yeah, I think the part I found especially kind of crazy is the hateful part, because they've jumped to a conclusion there. Like, nowhere did the parents say, we hate this or we hate you. It's just, we prefer for our kids to not watch this. Just like, if you're a parent and your kid asks you, hey, can I watch this movie? Like, you have total right to tell them yes or no. Does that mean you hate the movie? No. It just means that you don't think that that is something that you want your kid to watch. And that is a privilege and a right as a parent. I mean, even from the perspective of like what food your kids eat. If your kid is always asking you for, chocolate cupcakes or something, you're not going to say yes every time. It's not even, and in this case, I think it is a harmful thing, but potentially you're every time you say no to something doesn't even mean it's harmful. It is harmful to eat a million chocolate cupcakes, but one is not harmful. But like, I think in any other scenario, we understand that. Like, if your kid doesn't want to wear a coat outside and it's like snowing, of course you're going to encourage them to wear the coat because they're going to freeze and maybe catch a cold or something. Like, you're going to lay down the law and say, well, you're not going outside until you wear a coat. That is actually caring for your child. Do you hate the weather or something? No, like, that's a crazy conclusion to jump
Some people
to,
do hate the cold, Grace, but I know what you're saying.
Yeah,
you're right.
that's kind of true. But I just think that's, and it brings in emotional politics into the whole situation, which when it comes to, the legal side of things, I have a tinsy bit of legal understanding. And what I understand is that when you're arguing in a court of law, you're not arguing emotional ideas. You're arguing the law. You're saying, well, section whatever it is of this bill or whatever it is, says this is my right, blah, blah, blah. You're not arguing, well, they're such a horrible person, so you have to let me win this court case. Like, that's not how you argue in a court of law. And so this is like totally also opposite to the legal system and the way that we're supposed to do things. So yeah, which can be a little crazy sometimes. But yeah, I think that's kind of my reaction to that point.
Yeah, that's good. Let's pick that back up after we go to a short break here from the show. We'll be right back in a minute.
The attack on children online has gone too far. Most kids have been exposed to porn by age 13. That's why we created Tech Ready Family to bring you back control as parents. We believe that no parent should lack peace of mind over their child's safety online. Through our revolutionary Tech Ready Family course, you will gain understanding of the impacts of screen time and technology on the brain and discover the tools you need to mitigate the risks. So, don't wait. Get our Tech Ready Family course today and protect your children.
The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations. At the core of that duty are these parents' religious beliefs about human sexuality and gender. The Montgomery County School Board wants to disrupt petitioners' efforts to pass those beliefs on to their young children. But the Free Exercise Clause protects the parent's right and high duty. Breaking the bond of parent and child should never be the price of public education. That is from the petitioner's brief before the court in this case, Mahmoud v. Taylor, which we're talking about today on House to Home. The petitioner's brief just means the written argument for the side of the parents in this case. So, Grace, for what you said right before the break, I really appreciated, because you pointed out that this is not a typical oral argument before the court, and that usually, as you said, they're arguing about statutes or bills or case law, and they're just trying to figure out what the law says. But in this case, and as you could hear from that quote, we're clearly talking about a lot more than that, and you could hear that in the oral arguments here. They were talking about the actual record itself, what was going on, whether there was hate for these parents involved, was the opt-out feasible. These are all things that are usually, when you get to this point, decided in the record, the lower court level. And I just want I want to reemphasize to our audience, because they've heard me say this before, that when one of our core issue areas, these pro-family issues, gets before the court, more often than not, the arguments go well beyond what's normal at the Supreme Court, beyond just talking about statutes and case law, and they have to talk about the thing itself. That is something that separates our issues when they get to this level of controversy, is they have to talk about the actual thing in question, the parental rights, the right that was violated, the books that these kids were exposed to. This should have all been handled at the lower court level, but it usually isn't. You can see this throughout our history of Supreme Court cases that have gone up the chain, whether it was the Dobbs v. Jackson decision that overturned Roe versus Wade, or more recently, another Supreme Court case we're waiting for, which is the case over our help not harm laws. They had to talk about the thing in question, whether it was abortion or gender issues, respectively. And just like that here, they had to talk about actual parental rights and the actual material the kids were exposed to. So that's a good sign that this fits neatly into our issue areas, and I want our audience to know that. And I think it reflects a lot of popular opinion. So, Grace, why don't you tell us about some of the metrics we have about popular opinion on this issue?
Yeah, absolutely. And this is another reason why it's kind of crazy that it made it this far, because popular opinion, according to the Hetchinger report, the majority of Americans believe that kids should not be exposed to this kind of thing in school. And there was another research done by the Pew Research Center that said, again, the majority of parents also believe that they should have the ability to opt out of this kind of thing. So it's really interesting that we're even debating this at the highest level when the majority of Americans are on the side of opting out and really not even exposing kids to this in the first place.
Yeah, no, I completely agree. I think this is another, in political terms, what politics junkies like me would say it's an 80-20 issue. 80% of the country feels one way on this. And what that is code for is that means it's a losing issue for the side adopting the 20% perspective. So along that line, though, Grace, what we always like to do in this show is make sure we do give credence to opposing arguments. We're here to equip our audience to engage on these issues, and we want to make sure we are as generous as possible to the other side. So I think we should go into that segment now. So, Grace, I think I'll try to summarize what we have here for the opposing arguments, which is not strictly related to just this case. We've been through some of what the other side lawyers actually said in the case. We're now expanding our scope out to this issue overall, and this would be your counter argument you might hear at the coffee shop or on the subway on your way to work. And I think it's twofold. So it goes like this. First of all, the parents' religious and parental rights weren't violated in this case. These children were only exposed to the material, and exposure alone doesn't coerce them to change their beliefs. And then secondly, I think someone would say the state does have an interest in promoting inclusivity, as we mentioned earlier, especially of LGBT individuals. I think they would say those individuals face more discrimination than any other group in today's society. At least that'd be what you'd hear them say. So, Grace, why don't you take a stab at the first one, and then I'll come alongside you afterwards.
Yeah, absolutely. Well, The books in question, I think a couple things, and going back to our podcast with Sophia that we did a little bit ago, children are extremely moldable. And when you're trying to make the argument that you're not coercing them, but you're still placing ideas in their minds that are dangerous potentially, then I think you kind of lose the argument there a little bit. In a sense, you are coercing them because you know that anything you tell a kid, they just believe freely. They don't have a whole lot of natural, like, let me question this. Like, if you tell a kid that the elf on the shelf is real, they think the elf on the shelf is real. And so I think that's one point. But also, these books don't focus on basic kindness and civility. They focus on pride parades, they champion gender transitioning, pronoun preferences for children, and one book actually tasks 3 and 4-year-olds to search. Well, you mentioned this, to search for images that no 3 or 4-year-old should be searching for. To me, that is actually coercive. It's just like exposing a young kid to porn or something and expecting it to have zero effect. That's not how that works. That first part of the argument can be easily refuted.
Yeah, I think that's well said, and we spent a little bit of time on that in the first half of our show. I do want to definitely address the second argument that we mentioned about the state having an interest in promoting inclusivity. I can't acquiesce to the statement that LGBT members are particularly discriminated against in society anymore. I do think there may have been a time when we could make that argument, and that was wrong of us. That was a tragedy. But I don't think we can say that anymore. I actually think, and then polling shows this, plus we just have evidence to see that LGBT individuals are actually some of the most privileged members of our society. The previous presidential administration staff, for example, was overrepresented with members of that community, at least according to their population ratio. And that include people like former HHS Secretary Admiral Rachel Levine, who was a transgender woman, which simply means a man with gender dysphoria who thinks he's a woman. And then the First Amendment and parental rights of these parents, I would just say, I think they should quite obviously trump that unenumerated interest of the state. So there's nowhere in the Constitution that says the state has an interest in promoting inclusivity of a particular minority set of the population. But it does say that parents have these rights, that we have religious freedom rights, and that's why those specifically enumerated rights in the Constitution should trump whatever this other interest may or may not be. And here I'll just make a note to parse out those rights a little bit more. There's been a lot of coverage of this case saying that this is a parental rights case. I want to be clear with our audience that it is that, but that is not how it has been presented before the court. This is what lawyers would call a free exercise case, which essentially means it's your freedom of religion and expression of that religion that is at stake, not your parental rights. I'm a little disappointed in that, if I'm being honest, Grace. I think there are a lot of open parental rights questions out there and controversies, especially relating to LGBT ideology, that court watchers like me really need the Supreme Court to address. But they have chosen not to do that yet, unfortunately. And in this case, they're really focusing on the free exercise and religious liberty claims of the parents involved, which is why the final objection I want to deal with, Grace, and I'll let you close us out today, is actually from Ketanji Brown Jackson, one of the liberal justices on the court, or more liberal justices, I should say. She agreed with the Montgomery County board lawyers at one point in the oral arguments, who argued that parents could simply solve this problem by putting their kids in other schools, by putting their kids in private schools or religious schools, etc. And I think anyone who's followed FPA knows that that's not really feasible for every parent. Far from it. That's why FPA supports school choice legislation. But when Justice Brown Jackson agreed with them, I was actually kind of happy about it, because she basically made the case for school choice for us. This is why we would hope Maryland might consider a school choice bill. So I found that to be very interesting and just a worthwhile to address that smaller counter argument to show this is why FPA supports school choice, because when controversies like this arise, parents should be able to use their hard-earned tax dollars to direct funding to their child's specific education that they know is best for that child. That wouldn't eliminate all the concerns here, but it would help. So I think that's worth addressing before we close.
Absolutely. Well, this has been such a great discussion. I hope that those listening that this has been enlightening and useful to you. You've been listening to House to Home, a podcast by Family Policy Alliance Foundation. I've been Grace Youngson along with Joseph Kohm. We're here every week. We release a new podcast episode every Wednesday. So make sure to subscribe, follow us on whichever podcast streaming channel you enjoy, and leave us a 5-star review. We're super grateful for that. Also, share us with your friends and family. Get the word out there. It's so important that we stay on top of the latest issues. So we will see you next time. Thanks for listening.